that appellate court does not have the power to modify the sentence
not
in
saying
spite
that.
of sustaining the conviction.
My submission is that the finding is the erroneous, Your Lordship, not as per the record.
What finding? There is no.
Of the sessions judge, Your Lordship, kindly see the
Sessions
finding.
judge has confirmed the finding.
तो मेंटल तो हुआ ही ना,
मेंटल तो हुआ ही ना, बहुत तरह का मेंटल
और
टॉर्चर।
फिजिकल भी हुआ, मार रहे हैं, पति से मिलने नहीं दे रहे हैं, पति से अलग काम करवा रहे हैं अलग रूम में, दैट हैज कम इन द एविडेंस।
रेस्टिट्यूशन ऑफ कंजुगल राइट्स फाइल कर देना।
मेरा हस्बैंड गूंगा बहरा है, उसके साथ मेरी शादी कर दी गई।
आपने तो शादी आपको
preferred the appeal before the sessions court, and the sessions court pleased to modify the sentence, setting aside the conviction amounting rupees 1 lakh.
conviction set aside. No. Or this sentence modified.
Sentence was modified.
Conviction has not been set aside.
Criminal appeals were dismissed with this modification that in the sentence part only that 1 lakh rupees
Yes,
to be.
appeal has been disposed of by modification of sentence.
Yes. 1 lakh.
1 lakh.
Yes.
My humble submission is, Your Lordship, that the 498A punishment is 3 years and fine. And under section 386 of the CrPC, Your Lordship, the power of the appellate court says, and with the permission of Your Lordship, may I permitted to read this in
CrPC.
against the conviction, what the learned sessions judge has to do.
Yes, read please.
My Lord, 386B, Your Lordship, since the appeal was from a conviction, 1. Reverse the finding and sentence and acquit or discharge the accused. So it has not been done, Your Lordship. Or order him to be retried by a court of competent jurisdiction subordinate to such appellate court or committed for trial. This has
Reverse
also
the
not
finding
My
and
Lord.
sentence.
My Lord, reverse the finding and sentence.
He can sustain the conviction and modify the sentence.
My Lord, reverse the finding. First, the
Not
learned-
necessarily.
My Lord,
Then you see, we will not say that he does not have the power to modify the sentence.
my Lord,
He has
power-
got the power to.
but the finding is required to be reversed.
Not
and
necessarily.
The
Not
finding
necessarily.
of the learned
Not
sessions judge
necessarily.
is
Not necessarily.
that says the law itself. My Lord.
Not one. Every case we find that the appellate court is
Right.
modifying the sentence,
Right.
right? So please don't ask me to pass such a judgment.
My Lord,
That appellate court does not have the power to modify the sentence
not
in
saying
spite
that.
of sustaining the conviction.
my submission is that the finding is the erroneous, Your Lordship, not as per the record.
What finding? There is no.
Of the sessions judge, Your Lordship, kindly see the
Sessions
finding.
judge has confirmed the finding.
No, my Lord.
Confirmed the conviction.
Confirmed the conviction.
is-
Only modified the sentence.
If
My Lord,
he is finding that
kindly see, my Lord, para 9 of the improved judgment, Your Lordship.
Okay. Let us see. Para 9.
My Lord. The complainant was married with the younger brother
You
of
read
the
para 8 also.
My Lord,
You read para 8.
Lordship. In this case, 2 separate petitions have been filed on behalf of the accused appellant Manmohan Sahu. It is stated that instead of hearing the criminal appeals on merit, it may be decided by way of modification of sentence. It is further submitted that the appellant is ready and willing to pay rupees 50,000 each in both the criminal appeals, that is an amount of rupees 1 lakh. It is argued that the main grievance of the complainant is that she has been neglected by her brother-in-law. It is further submitted that the accused appellant Manmohan Sahu is bearing all the expenses of his younger brother, husband of the complainant, and a lenient view may be taken in view of the facts. As well, it is further stated that the appellant remained in judicial custody in both cases.
Correct or not correct?
This is the no, my lord, this is not correct.
He did not remain in judicial custody even for 1 day.
My lord, I am not saying only in respect of the judicial custody. I am
No,
submitting.
no. Just a moment.
My lord,
These facts may not be correct,
my lord,
but his submission was that only the sentence be modified.
my lord.
He never wanted any adjudication on the merits of the case. He just prayed that the sentence be modified. And then he also said that some justification he has given, whatever,
Right.
that he was maintaining the husband of the complainant, etc. And then he said that the appellant has remained in judicial custody in both the cases, right? So has he remained in judicial custody even for one day or not?
My lord,
If he has not remained in judicial custody even for one
Yes, my
day,
lord, he has remained
He
in
has
judicial
remained.
custody. Yes,
very fine.
my lord.
Then what else? You say that the judgment has been reversed?
Yes, my lord. Thereafter, my lord, para 9.
Okay.
There is erroneous finding, your lordship.
What erroneous finding?
My lord, I am submitting, your lordship. The complainant was married with the younger brother of the appellant, Manmohan Sahu, in the year 1982 up to that year 2003. That is for long 21 years, she was not having any complaint. This is the erroneous finding, your lordship. That would be clear from the perusal of the judgment of the
You
trial
see,
court.
the court has not entered into the merit of the case. The court has only modified the sentence.
Yes.
Whatever was the judgment.
But my humble submission
no,
is, your lordship.
whatever be the discussion,
Lordship.
the import of the order is only modification.
Modification, yes.
Right?
And I am aggrieved by this, your lordship.
So now you confine yourself that how are you aggrieved by this modification of
I am aggrieved, my lord, since the torture which I got twice by the hands of the, that cannot be compensated by the compensation, your lords. That is my humble
They
submission.
are not
your lords.
compensating it, they are modifying the sentence.
Yes, my lord. But I am dissatisfied due to that reason, and for that purpose, my lord, kindly see the judgment of the learned trial court, my lord. That not requires the modification at all, your lordship.
You have taken the money or not taken the money?
Not, I have not taken, your lordship. Page 33 of my petition, your lordship. Last paragraph. Almost all the PW submitted before the court that there was dispute between Janki Devi and her in-laws. Here it is important that most of PWs are independent witness. The statement of informant well corroborated with the FIR, IO of the case, well established the place of occurrence, which is at Bhandara near to Lohardaga Bhandara main road. So far as regard to section 498 A is concerned, it is necessary that cruelty must be caused by the in-laws. PW6, PW9, PW11, PW12, PW13 all submitted before the court that there was marpit was going on to the Janki Devi by her in-laws. PW13 submitted that Janki Devi came and saw mark of injury caused by marpit by her in-laws. Further, victim of the case Janki Devi said that she was not allowed to talk with her husband, which was well supported by the PWs, which was further supported by DW. DW in his cross-examination submitted that Janki Devi wanted to live with her in-laws, but she was not permitted to live with her husband. The statement of DW1 strengthens the prosecution case that Janki Devi was not allowed to live with her husband against her will by her in-laws. Depriving any woman not to live with her husband is also a kind of torture. In this prosecution able to establish the factum of cruelty caused to Janki Devi by her in-laws. So far as regard to section 354 of IPC is concerned, none of the prosecution witness had submitted that Manmohan Sahu had also outraged the modesty of the Janki Devi. Hence, prosecution has failed to establish the factum of outrage the modesty. So far as regard to section 3 of the DPA concerned, none of the prosecution witness said before the court that whether anything was given at the time of marriage. His prosecution has also failed to establish this aforesaid section. So far as regard to section 4 of the DPA is concerned, demand of dowry is to be made to the guardian, parents, other relative, bride or bridegroom. It is the settled law is that demand must be.
So there is no allegation of demand of dowry. That is why there is an acquittal under the provisions of dowry provision. There is no allegation of demand of any property.
Well,
Therefore, the only allegation is that there was assault. Just a moment. There was assault,
Right.
and she was not permitted to live with her husband.
reason behind this, your lordship.
No, whatever be the reason,
My
this
lord,
is the
reason
finding.
is very important, your lordship.
This is the
Since
finding.
Normally, my lord,
No,
Hasur
no.
having no role in such cases.
We will not
But
go
in
to
this
such
case,
an extent.
but in this case, no, my lord, that is the matter of record, my lord. My husband is dumb and deaf, and due to that reason, I have not been permitted to meet with my husband, your lordship. Since there would be the issue, and he will be the co-sharer, and due to that reason, I have tortured in this manner, your lordship. And thereafter, they have brought me, and after brought again, they have done same act, your lordship, and for that another case has been instituted, in which he has been also convicted against you, again, your lordship, and in which SI for 1.5 years has been sentenced and 5,000 fine, your lordship, and against which and the common order has been passed by modifying sentence in both cases, your lordship. That is my humble
So far, मेरा the
Just a
point
moment. आप तो अभी थे ही नहीं, आपको पता ही नहीं क्या हुआ बस.
जो बोल रहा है मुझे
आप
उसका
रुक जाइए please. Now we come to 498A.
My
Your case does not come under explanation B because there is no involvement of property or money or anything.
explanation B, your lordship. 386,
498A.
498. नहीं, उसमें हमारा नहीं.
A में है.
एक
हाँ बताइए.
हम निकाल लेंगे. हाँ, A में है जो.
A में है ना.
Money. Any willful conduct which is of such a nature and is likely to drive the women to commit suicide
ऐसा
or
तो
to
कोई फाइंडिंग नहीं है.
नहीं, फाइंडिंग नहीं है जो. अब हम तो
आगे-
नहीं
आगे-
किए, हम मजबूत थे, हम लड़े रहे
ठीक. आप मजबूत थे, लड़े रहे.
और रह करके फिर
Not a case for.
and to cause injury or danger limb life health whether mental or physical. तो मेंटल तो हुआ ही ना,
मेंटल तो हुआ ही ना. बहुत
अब-
तरह का मेंटल
और
टॉर्चर.
फिजिकल भी हुआ. मार रहे हैं, पति से मिलने नहीं दे रहे हैं, पति से अलग काम करवा रहे हैं अलग रूम में. दैट हैज कम इन द
रेस्टिट्यूशन
एविडेंस.
ऑफ कंजुगल राइट्स फाइल कर देना चाहिए.
मेरा हस्बैंड गूंगा बहरा है, उसके साथ मेरी शादी कर दी गई.
आपने तो
Situation
शादी आँख
ये
खोल
है.
के की है ना.
अब हमारा
ऐसा कोई
हस्बैंड
लॉ है क्या कि गूंगा बहरा कोई हो तो उसकी
रेस्टिट्यूशन
शादी
और
नहीं
कंजुगल
होनी
राइट का
चाहिए?
तब हम पिटिशन फाइल करते हैं हुजूर, जब मेरा हस्बैंड नहीं रखता हमको तब न करते हुजूर. यहाँ तो वो केस ही नहीं है कि हमारा हस्बैंड नहीं रख रहा है तो हम जा करके पिटिशन करेंगे.
आपको क्या बोलना है?
In this case, my only submission for lordship would be that although 14 witnesses were examined, husband is also one of the witnesses who should have been the best person to support the case of the complainant. He has not been examined.
Husband has not been.
बोलता ही नहीं है
Number
तो
next.
कहाँ से एग्जामिन
तो
होगा.
इशारा से होता है. गंगा का भी विजन है ना.
नहीं तो आप डीडब्ल्यू के रूप में नहीं लाए हैं उसको.
हम कह रहे हैं आपका केस नंबर 1. नंबर 2, there is no injury at all. Doctor has not been examined. No sheet of paper before the court to deduce a thing that
That's right.
he was.
लिखिए.
386 में जो पावर है सेंटेंस को मॉडिफाई.
And it is not a case that there has been no period of custody. कुछ तो रहा है custody.
कस्टडी में 3 महीने.
3 महीने दोनों
हाँ.
केस में.
हाँ, जानते हैं. उसमें there is no dispute. वो सब देख के ही किया गया. ये वेलफेयर नहीं चाहते हैं.
Criminal Revision number 271 of 2019.
टेक योर लॉर्डशिप.
हाँ.
ये अपीयरेंस जो रहा.
इनका appearance record कर दो दोनों का. This revision has been filed challenging the judgment dated 13/2/2017 passed by learned Sessions Judge Lohardaga in Criminal Appeal number 13 of 2014, whereby the conviction has been upheld but sentence has been modified. The petitioner is the informant of the case. the appellate court, while dismissing the appeal, has modified the sentence and has directed the petitioner to pay an amount of rupees 50,000 for the case being Bhandra PS case number 29 of 2003, trial number 42 of 24. Parties that the petitioner has some to be paid capital A. Sorry? Being the brother-in-law. Brother-in-law of the petitioner was convicted of an element. Counsel, while giving the background on record that
she has been deprived.
that's right. We have read the finding.
DW1 examined on behalf of
The learned counsel appearing on behalf of the opposite party number. So it cannot be said.
paragraph 13. Now supervised.